Hey, right, everyone, just bear with me. Just doing the usual stuff here. Um, right, as always, guys, please don't share personal data in the chat. Just ask questions as if they're about. Oh, hold on a minute. There we go. Yeah, usual. Yeah, don't just ask questions as what if questions, and don't. Essentially, just kind of put it in the third person. There's various reasons to do that. One of which is making sure you don't have to put your personal data online to get an answer. And it's not legal advice. We're going to try our best here to be helpful based on the information we've got, but it's never going to be perfect. Um, what's going on? So YouTube's been weird. At the moment, it says there are um, two live streams simultaneous at the moment. Let's just close one of them down. Cancel. No. Okay. This is weird. This hasn't happened before. Just going to try and figure out what's going on. So yeah, hopefully, like you guys are in the right one. All right, let's just hope that's all right. We'll find out in a minute. Yeah, cool. Okay, so yeah, welcome everyone. There's been quite a few questions coming through the week, so we'll start with the ones which have been anonymized, and then there's a couple which weren't, so we'll do those last. It's just my way of trying to incentivize people to anonymize questions. Don't know what else I need to say at this point. Yeah, we'll save it. I don't think there's been any kind of interesting news this week, or has there? I'm not sure. But yeah, if we think of it later on, we'll put it in there. I might need to dash off at some point to pick my daughter up, so we'll see what happens. But I'll just make Shannon co-host so she can, yeah, kind of manage things as we go. So yeah, first question from the week is, uh, basically it's about landlord harassment. Let me just zoom in and stuff, make it all big. Um, there we go. Cool. Get going in a minute. Oh yeah, there's a little bit actually a bit of news for me. Next Tuesday afternoon at 3:30 p.m. I'm hosting a webinar. I think Will's going to be there as well, looking at intentional homelessness in more detail. So, yeah, if you're interested, you need to have a look for homelessness best practice on Eventbrite. It's free, but you need to sign up to it, otherwise you don't get the link. So yeah, so you just check it out. Basically, as I say, it's like an hour and a half. It will be recorded, so if you miss it, it'll be up on the YouTube channel at some point in the next week or so, or week afterwards, or whatever. But it'll give us a chance to take questions and kind of have a bit of a conversation about it, and also just look at various cases and stuff. We're not going to go into full detail because actually intentional homelessness gets really nuanced in certain obscure bits of it, but we'll just kind of focus on the common kind of situations you're going to come up against. So yeah, here's the first question, and I don't know the answer to this. What if a landlord is harassing a tenant, damaging their possessions, trying to illegally evict them, and has turned off utilities? I think electric and water potentially. I might need quoting on that, or might need to be corrected on that. But does the council have powers to take action against the landlord? So the situation is that this person appears to be kind of have some support needs, some difficulties they're managing. Potentially, some of those might just kind of make them an easy target for a horrible landlord, and they've walked into the council and explained what's going on, or they explained part of what's going on. They didn't report the damaged property that the landlord had smashed up. Um, so yeah, we'll leave that aside for the moment. But they went in there, and effectively the council said, yeah, go to environmental health, and go to the police about the kind of harassment. And I guess the question is the council not supposed to potentially intervene in a kind of a situation like this where there is harassment and yeah, potentially take action against the landlord? So yeah, I don't know the answer to this. I'm probably looking at you, Will, because you're probably more familiar with these kinds of situations than me and Shannon. So I don't know if you want to have a go at this one.
Yeah, the simple answer is yes. Um, being the council does have powers, and it's under the protection from, well, I think I'm not sure the actual chapter and verse of it, but I've sent a link on the chat to Dartford Borough Council's website, which I got to by Googling this question. And Dartford has a section of its website saying, if as a tenant your landlord is threatening to evict you without a court order or is harassing you with the intention of making you leave, which is sort of what the first half of this question is saying, you should contact the private sector housing team. And so they described themselves as being an enforcing authority for the for Protection from Eviction Act. So they can prosecute, and they could also take, well, I think they could also take civil action, but it's better to refer the tenant to a solicitor because it would be the tenant who'd need to be the claimant. Um, so that the answer is yes, but there's a bit of a but in that I tend to find with a lot of local authority stuff, they've been so cut back over the years that the people that used to do this job have tended to be have their jobs cut, so they don't do it. So if you went to the council and said, um, I understand that you're the enforcing authority for the Protection from Eviction Act. Can you help me here? They would probably say, "Don't know what you're on about." You know, and because it might be so long since they actually did it. But that raises the question of whether they should be doing something. And the answer is probably yes, because where a local authority has the power to do something, if they unreasonably refuse to exercise their powers, that's unlawful, and then you could challenge it by way of judicial review. Um, but the irony is slightly that if by the time you got a lawyer who was confident enough to challenge a local authority's refusal to take action, you might as well use the lawyer to take civil action against the landlord. But the prosecution, I mean, you could report it to the police, but the police are notoriously bad at dealing with this sort of thing. For some reason, there's a sort of blind spot when it comes to landlord and tenant, and they often end up, they're more likely to help the landlord evict you than they are to stop it. Um, so I hope that's a short answer. The answer is yes, but you've got to try and see if there is a tenant, a private sector housing team. They may have them, but they may be hidden away. So try and persist. And if you don't get anywhere, try and contact your local councillor or something and ask them what the council are doing. And you can do that from web Google search for who your local councillors are.
Yeah, cool. Shannon?
Yeah, it's not hugely helpful compared to Will's answer, but lots of utility companies have like a priority service register and stuff, and that's for the resident, not like the owner of the property or bill payer and stuff. It's for residents. So potentially it's worth contacting the utility provider, explaining the sort of situation, potentially registering for these priority services, which means that you can't get cut off. So even though if you're not the one paying, you still might be able to access those services. It might be worth a shot. I know it's not tackling the actual sort of problem, but in the short time, yeah.
Yep. I I mean, I guess that leads to a question which I'll put back to Will. Like, so if you've got a property where there's no running water, let's say that is the case, and I think it is, and no electricity, is that at what point does that kind of stray into the world of actually being homeless, as in it's unreasonable to continue to occupy?
Yeah, good question. So if
Because
you're
I think,
left without electricity, I would say straight away, really. Especially, I mean, if if you're there and you've got children and you haven't got utilities, definitely.
yeah, I mean, I think um, I have a feeling it's going to come to a bit of an argument with the local authority on this one. So, in fact, going back to your the previous bit you said, Will. So you're saying, I mean, I was expecting you to say that the councils can do quite a lot in this situation if they are so inclined. I guess the question would be: is there a duty to? Like, do they have to? If a vulnerable
Well,
person says, "I'm being harassed by my landlord," does that not really put a requirement on the LA to do something about it?
well, I think it does because if you legally, the role of the council is comes down to discretion, so mandatory duties and discretionary powers. So the best example of that we're familiar with is that where somebody is meets the requirements of Section 188, the council's under a mandatory duty to give them accommodation. Whereas when they've made a negative 202 decision, they only have a power, yeah,
Yeah,
a power that is unlawfully withheld, or sort of a power where there is good reason to exercise it, is arguably pretty close to a duty.
yeah,
So if they have a power to help somebody who's in the situation here, who's not got utilities and things, then it would be unlawful if, I mean, they could have a good reason. if they said we don't believe you, or we think you've got another place, or something like that, or I mean,
They don't have a good reason. I know that much.
yeah,
I think they believe him. I think they believe the tenant. Yeah.
if they showed that they thought about it and come up with a good reason why they didn't have to exercise their powers, but if they just said no, we're not going to do it, go somewhere else, that would be unlawful because they failed to engage with the question really.
Okay.
And I would say, and this is one of my things. You're right, it does overlap, but you've rightly raised it that if you went there and you said, and this is how it should work post Homelessness Reduction Act, is that you go into the council and you say, "Help! I'm in this situation. My landlord's done this and that." They should be able to do an assessment and say, "Right, well, we now understand your problem and we can help you in the following ways." And one is we can accept a duty to provide you with temporary accommodation because you're homeless. Meanwhile, we can take action to require your landlord to get you back in, and we'll accept a prevention duty, and we'll prosecute as well. And we'll refer you to a solicitor. It also is starting to get a bit sort of fantasy unicorn land, but this is how it should work,
Yeah,
isn't it?
yeah. Fantasy Unicorn Land, where the council actually follows the letter and the spirit of the law. Yeah.
Yeah. Well, everything that should happen. But the thing is, the danger with doing this work is that you mustn't let yourself get. I mean, not that we are, I don't think, get jaded to the point where you say, "Oh well, As a judge, there was actually a judge said this to me. I still haven't got over it. There was a seriously disabled person, and he said, "Oh, this is the sort of thing where we would have asked social services to help, where they still had the funding to do it." And I thought, well, no, they did. It's not funding. It's not subject to funding. They have a statutory duty to do it. So we have to keep asking for the sky and let them tell us why we can't have it, but not to give up. So I would say, if somebody has got this situation, they should go to the council and they should get a holistic, global approach. Well, they won't, but they should, and they shouldn't be put off asking. Um,
Yeah.
and they should go to a solicitor who could hopefully challenge that.
Yeah. Cool. Okay. That's helpful. That seems like a thorough answer. Um, so question two, I don't know the answer to this one either, actually. So basically, there's a mum whose children are currently in foster care. Mum's now in a much better place. I don't know what the history is. And like children's services are basically saying, or in fact, I think a judge has said the children should be returned to the mother like in a staggered way. So like, kind of weekends, starting for weekends. Now, we've talked before quite a bit on the channel about where you've got like a couple where a judge makes a particular order that says, the child will live with the mum or the dad or kind of 50-50 split or whatever. And that's not kind of yeah, like housing teams can essentially disregard that. And if in effect, judges shouldn't be making a kind of an order that would affect homelessness duties. That's my understanding. But in a situation where you've got children's services basically involved in saying this child should be returned to the mum's care like in a staggered way, does that mean it's reasonable or the child or the children should be reasonably expected to reside with mother and therefore kind of be treated as a single household by housing? Does that make sense? I'm going to go for you first, Will, because again, I think this is going to be your
Yeah, my
expertise rather than
view
ours.
is that the mother is entitled to be how is entitled to assistance, because the test is whether the children are residing or might reasonably be expected to reside, and
Yeah,
that means at some point in the future. Um, and bear in mind, so basically, if the plan is for the children to be gradually returned to live with her, and I assume that's what the order means as opposed to
yeah, I
care,
think so. Yeah, yeah,
then obviously that's a reason to say that they might reasonably be expected to reside. And one thing's for sure, if they don't have any accommodation, then that's frustrating the plan. And the other thing to bear in mind is that if they're in foster care, then the foster parents are presumably accommodating as a result of a care order, which a local authority have obtained. And so it would be very unusual, and there would be a court order. So it'd be very unusual that a judge would not be interested in what's going on with the housing. So the difficulty, and forgive me if this is too complicated, I'm going off on a waffle, but the county council is the one that has the Children Act authorities. So if this is outside London, you may
It's
get,
unitary. Yeah. No,
if it's unitary,
yeah,
that's
it's
great because
yeah,
the judge in the family proceedings could give a direction that somebody from the housing department put in a statement saying why they're not assisting in facilitating this order, which the council are presumably in agreement with, or the court has ordered, because otherwise the children, it frustrates the court order.
yeah. Okay, that's cool. Thanks very much.
Okay.
I'm still a little bit suspicious that YouTube's not running entirely possible here, but yeah, just if you are listening, give us a shout out and say hello, because I can't work out if there's some people waiting somewhere else in a different live stream and it's kind of like pending or something, because it seems to have done it twice. But anyway, yeah, cool. Thanks, Will. Question 3. Here we go. It's a long one. So I have a client with highly complex disability and homelessness case. I know what you said about the time limits for taking something to the LGSCO, but this situation has now been ongoing for a very long time, over 390 days at the time of writing, without the client ever being provided with temporary accommodation. They've effectively remained in the university hall of residence only because the university wasn't inclined to go to court for eviction. I'm concerned they could lose out on a potential compensation due to the passage of time, but I also note what you said about the risks of victimisation, of being placed in worst possible property after making a complaint. The client needs fully adapted accommodation due to disability and is terrified of being housed 100 miles away with no support system or an institution, which has actually been threatened by housing officers during an in-person meeting. In your view, would you still go down a formal complaint route of this kind of catch-22 situation, even while they're unhoused by the council? So I have a feeling this question might have cropped up a couple of months ago in terms of like the nature of a license or a tenancy in student accommodation. I went back and kind of got clarification from this person, and they basically said, yeah, the course has ended. Yeah, literally they are only there because the university won't kick them out. And I think we might have said last time that in one sense it's actually going to help the situation out if the university um, actually do something. Although it seems, I think our conclusion last time was that someone in this situation would already be legally homeless. It's obviously not reasonable to continue to occupy this accommodation indefinitely. So they should be treated as a homeless person by the council, even if there is still a roof over the head. But in terms of this kind of question about the complaint, in one sense, although it might have started 390 days ago, it's still happening now. So in one sense, that as far as I understand it, the time limit is essentially it's happening now. You would still have 12 months from today if the situation was resolved today to still get it through to the LGSCO. So I think that answers the easy bit of the question. The hard bit about what should you do, the risk of some kind of retaliatory action by the council in terms of just being really unhelpful and giving the worst possible property type or something down the line. I don't think we can give a, it's possible. No, no idea how likely that would be. It might be very unlikely, but still technically possible, or it might be very likely. I mean, legally, someone in this situation has got the law behind them because they've got disability and they need fully adapted accommodation. I'm assuming this is all kind of this is probably has already been accepted by the council. So yeah, I think really I think the compensation is still possible to claim 12 months from now, as far as I would read it. The more important thing here would be to get the council to act lawfully now. So which might need a complaint being made or might need a solicitor getting involved, basically. If a solicitor is not realistic to get involved, then it would be a case of contacting local councillors or whatever and explaining the situation to see if that will move the council's position. But I think that would be, I think, as much as I'd be able to say on this one. Anyone want to add anything to that at all? No. Okay, cool. Yeah, so I think yeah, I think the urgent issue here is the fact the council's not engaging with the process, and the thing about kind of like being housed 100 miles away, that's not that probably isn't legal here because of the support system, the need for the support system, which again I'm expecting is probably quite easy to evidence if someone's kind of got, kind of quite a considerable disability by the sound of it. Yeah, so I think that's kind of like, as I say, the law's on this person's side. It's just a question of actually getting the council to follow the law. Councils absolutely can find accommodation much closer than that, and essentially have a legal duty to. So if you want to kind of get a bit more of an understanding of the legal position, check out a case called Imam v Croydon, where it was a case about suitability of accommodation and additional needs, kind of like a need for adapted property in some kind. And effectively, the Supreme Court judge said to Croydon, "You're saying you haven't got any money. You can borrow money then to build a house if you need to. That's the way the duties work." So have a look at that case. There's a video about it on this channel actually from a few months ago. But I think that will just kind of give you an idea of like, the fact is that the council has a duty to do something that is non-negotiable, non-deferrable, has to happen. So plan A would be to, plan A would be to get a solicitor. Plan B would probably be to involve local politicians. Plan C would be to complain. That's probably how I would look at it. So yeah, hopefully that's helpful. And yeah, sounds like it is a bit of a catch-22 situation, isn't it? But yeah. Question 4. So, and I don't know why May 22nd here. I'm not sure if I've misread this or something, or got the wrong date on it or something. But yeah, what if court has given you until May the 22nd to vacate the property and the council does not change priorities? What if you need help claiming compensation but cannot find a solicitor who can help? Who can you go to before the bailiff arrives? So I am not entirely sure I'm understanding the question entirely, but there's certainly some bits I can help you out with here, which is, one is solicitors don't ordinarily help you with compensation anyway. It's not within their remit. You can claim compensation without a solicitor just by complaining and taking it through to the LGSCO. And if the complaint is about being told to wait until the bailiff arrives, yes, you can probably get compensation. No, it won't be a huge amount, but it will certainly be more than the cost of the court costs. It's usually kind of court costs plus, sort of a few £100, maybe £500. To find out more, if you look on the channel, I think there's like 3 or 4 videos now on the channel which have the word bailiff in the title. If you search for the term bailiff on the channel, you'll get the videos. And certainly the longest one of those gives some examples from the LGSCO of cases where they have been upheld. And since we're here, I might as well just show you the decision database, because again, it just kind of gives you a bit of a cheat sheet really. So hold on, let's get the so if you I'll put this link. In fact, this link is always on the description of the videos I put up now. So if you this is like, it's on Will's system, but if we just type in the word bailiff here, we should get all these cases here. And effectively, you pick one at random, you get this number here, you copy and paste it when it lets me. Hold on a minute, Zoom's been weird. There we go, into the LGO decision database. You'll get the decision, and it just basically explains how it's considered by the LGSCO, what the law is. And basically in this case, Miss X got £500. And I feel like there probably would have been court costs in there as well. It might not be mentioned right at the end there, but yeah, if you just kind of read through it, this will give you an idea of how it all works in practice. The LGO website is amazing when it comes to understanding how the law works in practice, and also just kind of cuts through gaslighting by local authorities. So if you've been told, everyone has to wait until the bailiff comes, that's what the law says. You read this and it'll tell you why that's not true at all, and what the law actually says. So have a look at that. Go on any other video on the channel, recent video, you'll find those links. So yeah, I'm going to go pick up my daughter in about 5 minutes. So I'll leave you in Shannon and Will's capable hands. We haven't got any questions coming in the live chat yet, have we? Am I missing something? I don't know. Feels like there's usually a few questions by now. Hopefully I've not.
There's usually at least a few comments.
Yeah. As I say, maybe it's just us. I don't know. We'll see what happens. Cool. Am I even sharing my screen right now? No, I'm not. There we go. So yeah, question 5. Right. So similar issue here, but slightly different question, I guess. What if a person is going to be evicted by bailiffs and housing officer asks the family with kids to go outside London and use some schemes like Home Finder UK and others? If the family has needs to stay in London, how should they approach it? So probably the best way to look at this is to go and search for a case called YRV Lambeth. Now, I remember me and Will did a video about this on the channel ages ago, like a couple of years ago now. So it's not even called YRV Lambeth, so I don't know if I could find it right now. But if you search for YRV Lambeth, literally the letters YR and then Lambeth, that is a case where a family from Lambeth was housed in Gravesend. And if you Google it, the one of the first links that will come up will be Nearly Legal, which is a really amazing blog by Giles Peaker. And I think the title of that blog is called Cascading Unlawfulness or something. And it explains how the law works in terms of, suitability of accommodation in general, but specifically location, and how that the council in that case, Lambeth, had failed to correctly identify the needs of every household member. So it was about the kids as well as the mum, and therefore that decision was found to be unlawful. So that's what the law says. Getting councils to follow the law is 90% of the challenge, unfortunately. Again, if you can't get a solicitor, trying to contact a local politician, particularly a councillor, might be your best bet to try and get some kind of sensible response. But just remember, when London councils say they can't find any housing in London, there are plenty of London councils that are absolutely fine finding housing in London. So it's kind of a more a political choice rather than an actual reality. So yes, it is difficult, but some councils manage it. So that means all councils can manage it if they put their mind to it. But I think it'll be a case here about really making sure the councils got all the information they have about the support needs of the family. Might be disability stuff. It might be kind of, other kind of family considerations, and just making sure the council has all that stuff. But it's a difficult one, and I think ultimately what we'll always say about this situation, if the council offer you something miles away, take it and then challenge it down the line. Don't refuse it, because you just make your life very difficult to come back from, really. So just accept it and just kind of, try your best to kind of push the council to make a good decision, but don't refuse accommodation. You're paying, it's a very high chance that it's just going to fall through altogether and you won't have anything. So so I've got to duck off. Shannon, you've got the questions, haven't you? I don't know. I don't know if you. I'm not sure if you can share. I'll unshare the screen.
I can share
anyway.
my screen.
Yeah, you okay doing it? I'll be like 5 minutes or something, so I'll be back in a minute.
Yeah, no worries. But bear with me, guys, if I do. Right, so the next question, because I can't see any in the live chat, so this isn't anonymized. But my child receives DLA, and I fit the definition of disabled under the Equality Act. Yet the council said we do not meet the threshold for the category of disabled within their housing scheme. I questioned it and they stood their ground because they did give me medical priority on the lowest band, but I don't need an adapted property. Is this worth pursuing further for the housing register? I'm about to be homeless now, so trying to understand how relevant this would be for section 7. I think they mean part 7. But kudos for even recognising that, as we'd already had priority due to my child. The main concern is anaphylaxis risk, allergies. I have plenty of evidence, including a council paediatric OT report stating need self-contained, fully fitted kitchen, must avoid all cross-contamination, etc. I'm very worried once we trigger the homelessness duties, they'll offer us a hotel or B&B or even self-contained bedsit, which would still carry unacceptable risk. But even the OT told me she sees children in wheelchairs placed on 9th floor flats with no lift, so it feels very demoralising. I'm also in family court proceedings, so cannot leave the area, London, and I'm worried they might offer PRSD, private rent, out of borough as soon as they can get us off their list. So, I mean, it's difficult because they say about to be homeless now. And if you are at risk of homelessness within a certain amount of days, you would legally be considered homelessness now. So making a homeless application under Part 7 potentially could be done now. In terms of suitability of temporary accommodation still has to be suitable. It can be less suitable than sort of settled accommodation, but it still does need to be suitable. So making sure, and you've got all of that plenty of evidence, but making sure you've got it really clearly laid out in terms of needs and the type of property, I would recommend, and Will, I'd love your thoughts, but if it was me in this situation, I think I would recommend triggering the Part 7 homeless application sooner than later, because you're giving the council, the local authority, you're giving them time to find you suitable temporary accommodation. So once you trigger that duty, it doesn't necessarily mean you have to jump into temporary accommodation that very day. If you still, have a couple of months on an eviction notice or whatever it might be, but you're giving the local authority adequate time to find you suitable housing, particularly when you've got all of the evidence. And you'll do like a personalized housing plan. So again, putting all of that in there, all of the reports, everything else is really important in terms of the Part 6 side of things and the housing register side of things. That would depend on your local allocations policy. So if you Google your local authority's name and allocations policy, it will come up with all the banding. You seem to have a good understanding anyway of that banding because you've challenged it and what have you. But many allocations policies, once you've triggered the Part 7 duty, you will go up in banding because you have to be given preferential treatment basically. So potentially you would go up banding anyway, which would then increase your chances of getting that social housing. Will, is there anything you'd like to add, please? Anything I've missed? You're on mute.
Yes, I would just going through the question in the order of things come up, where she says, I'm assuming this is a woman. Sorry, that the question of whether disabled under the Equality Act is the same as disabled under the allocation scheme. It may be worth checking the actual wording of the allocation scheme, because they may be using the term in a slightly different context. So that it could be that you need, and the reference to adaptation there may be relevant in that if you need the accommodation or you need to move because of a disability, then that may be relevant to Part 6. Whereas just because you have a disability, for instance, if you I don't know, were unable to do a particular activity, but it didn't affect your housing needs, then that wouldn't necessarily mean that you were disabled for the purposes of that. So it may be that they're different, but it's worth checking out. The other thing, I totally agree with you, Shannon, that you should let them know as soon as possible, because the danger of leaving it longer means that there's more risk of you being put in unsuitable accommodation. As bed and breakfast can only be used for 6 weeks in an emergency. So the sooner you do it, the more difficult it is for them to say it's an emergency. And as for the last bit, I mean, that advice about they've seen loads of children in wheelchairs put in ninth floor flats with no lifts. I mean, I wouldn't have thought, and I mean, that doesn't sound like a very lawful situation. And I would hope the OT would add, and all those cases have been successfully challenged as unsuitable, but I doubt it. But I mean, I don't use Shannon. I think those are unsuitable. I mean, they're definitely unsuitable.
100%. And in terms, I guess, the family court proceedings, so cannot leave the area. I guess it's again providing evidence of that, and sort of making the housing officer aware of the importance of why you need to stay in the area, for those sort of family court proceedings. I just want to check, Will, can you still see the Word document? And you can't see the
In
YouTube
the
that I've
shared
got up.
screen, yeah, it says my child receives
Perfect,
DOA.
because I've just seen in the YouTube channel there's an addition to this question. Question
Well,
6, in accelerated possession proceedings, but section 21 is invalid. So the council refused to accept homelessness duties for now, so I want to use this time to do my best to avoid unsuitable housing. Um, Let me add that in.
okay.
Okay, so the homelessness duty wouldn't actually be able to be triggered yet then, because you're not actually at risk of homelessness, but it's still worth, I think, getting all the evidence together, and potentially, will, I don't know how much luck you've had with this, but having informal chats with housing officers about like your needs upcoming. um Potentially you've already done that with sort of the housing register side of things, but I think the advice we've given still stands.
Yeah, the thing I would add is that the prevention duty generally only kicks in if you're at risk of homelessness, I think within 56 days. Is that right?
Yeah,
But the thing is, the code of guidance, and I think, if not the act, says that there's nothing to stop councils considering steps to be taken early on. And where where the child has special needs here, it could be worth asking them to start an assessment early so that they can minimize risk. But they may just
yeah,
delay. But I would have thought even you could ask, because a disabled child will be a child in need for the purposes of the Children Act as well. So you could try and get children's services involved, and say you're worried about the risk of them getting unsuitable accommodation.
yeah. And this person is doing all the right things in terms
Yeah.
of the preparation and evidence. Um, Yeah, and they've just put in the YouTube chat, I want to be prepared, mostly worried about. So you're doing all the right things, getting all that evidence, preparing for it. And like we said, triggering part 7, the homelessness duty, will give the local authority more time to find you suitable accommodation. So I'm going to move on to the next question, unless Mike, I see you're back. Do you want to take over?
No, oh, it sounds like you're doing a good job. Yeah, I think
I
there's one
mean, the
more question,
text
isn't
is all
there?
different. Yeah, this is the last question, but we have finally had a comment on the YouTube, so we're working.
Yeah.
So question 7. I filled out the financial statement and clearly don't have enough money to afford private rent. That is with me claiming PIP. Housing benefit for UC is capped and I'm paying £300 over, which I have to use my PIP for. My question is, should this be allowed? If it were to stop, there's no way I could afford rent and eat. Should my PIP not be for medical uses around my disability? Can the council force me into private accommodation far away from my support system just so rent is lower, but still leave me with zero or most months minus money? I forgot to state I've been served a Section 21 eviction and bailiffs are due in a few weeks, so I'm getting nervous as my health is quite bad. So,
Ooh.
I mean, in this situation, it kind of sounds like the person is potentially homeless anyway due to unaffordability, as well as obviously the Section 21 eviction. I think if you haven't already made the Part 7 homeless application to the local authority, the council can't force you into private accommodation, but they can discharge their duty into suitable accommodation. So what they'll do as part of that process with the personalised housing plan is they will do an income and expenditure form and work out what you can afford each month. They can't discharge you, so they can't house you somewhere that is unaffordable, because you would still be legally homeless if that was the case. So it's definitely worth having a look at your finances, and I don't that mean that in like a patronizing workout where you can cut corners. I mean that in a right, how much is coming in, what's going out, what's realistic in the area you're in, how much is rent per month, what's the LHA rate, how much a bill is going to be if you move into a one bed property or a bed sit, and various things, and sort of try and come up with a bit of a plan ready for that meeting. But yeah, they can't force you into private accommodation, but they can do if it's suitable and affordable. Mike, did you want to come in?
Yeah, I mean, just like so, the question about like can they take PIP into account at the moment appears to be a question that's not clear cut. I mean, I've seen knowledgeable like advisors or whatever like side or go both ways with that. So some say that the PIP is completely ring fenced. It's none of the council's business what you spend it on. I've seen other people say that essentially, and I think this is probably more likely to be the position, although it's not set out clearly in case law at the moment, to be honest. Where basically, if let's say you're getting £100 a week or something from PIP, but you're only spending 80 of that on things related to PIP, then the council could look at the other £20 and kind of consider that to be free available income to spend on other stuff. So I don't there's a couple of cases that basically made it very muddy, and I've not seen any signs that it's getting any clearer since then. So I think that's most likely the position. But as I say, I've seen knowledgeable advisors basically say it's part of your human rights and kind of right to a private life. It's not means tested. It shouldn't be. That they would argue that you don't even have to declare it. Now, as I say, I don't think that's right, but I guess it could be. And I think just in terms of like No, in fact, I've got nothing to add to what you said, Shannon. It's all good.
And I think just to add as well, if you are on PIP, you are likely to have a disability. So again, when you're interacting with the council, right from the beginning, declare that you have a disability. But even more importantly than that, make it clear as to what your disability might require. So any reasonable adjustments around that, whether that's like communication and letters or phone calls, whether it's actual adaptations to the property, whatever it might be to make this situation suitable and accessible for you, make sure that you're declaring that at the beginning of the process. And the personalized housing plan should be a collaborative situation. So again, if you say, for example, and I obviously don't know this situation, but you have diagnosed anxiety and your concerns is around affordability, noting that in the PHP will hold some weight, particularly if your PIP's up for review in the next 6 months, then actually and they need to discharge a housing that's going to be suitable for 12 months, that's worth noting. So being aware of when your next review of PIP is, for example, or whatever it might be, and your actual needs relating to your disability is really important here, and getting all that evidence as well in terms of priority need, in terms of your housing. Will, would you like to add anything?
Just a tiny bit, which is I don't know if you've heard me say this before, but you probably haven't, you probably would hear it again. Whenever I hear the word support systems or support network, which is another term that's used in the same context, I'm always aware that people may underestimate the need to specify what that is, because the councils hear this all the time. I need to be near my support network. And they generally ignore it because it's when you actually press people on it, it's difficult to come up with something concrete a lot of the time. I mean, it may be, for instance, I've had clients in the past who say suffer from epilepsy, and they have a network of people that could help them collect the children from school if they're, or what's the word, migraines. And if you can demonstrate that. What I'm trying to get at is I'm not saying that this person doesn't have a need for a support system, but you've got to be ready to fight your corner and justify that, because what you'll probably get is a letter from if they offer you something out of London, which is a real danger that can't be ignored, that you'll get a letter from the council saying, we've thought of all these things, we've got an advice from our medical advisor that says that there's nothing too serious, and there's an NHS which is national. You can get help from social services, and then it's so you don't need a support network. So you've got to be able to come back and say, yes, I do, for the following reasons. And it could be that the support network is an emotional support as well. It's not just somebody that comes around and does the washing up for you or something. So just think about that. What you need to identify is what it is that you get support with, who it is that gives you support, and why it is that they wouldn't be able to give you support if you were a long way away. I mean, that last bit's a bit obvious. And
I
why?
think
Yeah, sorry, go on.
No, I was going to say, I was going to ask you a question, but do you think it's also worth highlighting the impact if that person didn't have that support?
Yeah,
So what would be the situation if that person didn't have that support system in place? What harm would they come to,
yeah,
etc., etc.?
yeah. And also get supporting letters from the support network, because you've got to identify the support network, because usually they'll just say what you mean your mates or something. Everyone likes to have friends, but unfortunately, you can't, because you can't afford to live in London. That's what they'll be saying. But then you've got to say, well, actually, so and so does this or that for me, and here's a letter from them saying the reason I do this, and most of these people are doing it for free and putting themselves out, so they must be worried about the person. Is that, and also it'd be worth talking to your doctor about your worry about what would happen if you didn't have the support network, and why you may need something different from just a plain um, access to the NHS, which at the end of the day, they don't tend to do home visits unless you've had a Care Act assessment. So yeah, I mean, and probably are overdoing it to say get a Care Act assessment while you're at it here. but it can't do any harm. So you could go to social services if you think that you need support, but that may be playing into their hands because then they can say, well, social services can meet the needs anyway.
Yeah. Cool. Thank you, Will. I can't see any more questions, Mike, either on the live stream or via email. So
I think that's it for this week. Yeah.
I've
As
put.
I think we've lost some of the regulars, so I don't know
Yeah.
if they're going to be like sitting in limbo on some other live stream right now. But yeah, it's obviously recorded, so hopefully people can catch up. But I think sorry, Will, go on.
I put a link in the chat, another one. The Garden Court Chambers have just put the video on YouTube for their guide to the Renters Reform Bill, or the Renters' Rights Bill. So if you want to know an outline of how the law is going to change, if it ever comes, I don't think we have a date yet, but one of these days there'll be the Housing Act 1988 will be amended or replaced with this new set of rights. And so that's all the Section 21 stuff. So if you watch this video, you'll get a. I'm looking forward to watching it because I don't know anything about what's coming in. I've sort of avoided it because I just think I'll get headaches and then it'll all change at some point when the government. But I think it's now in a final format, so this will give you an idea of what's coming, what to expect.
Cool. Yeah, I'll have a look. I've just put it into the live stream chat, so and I'll try and remember to put it into the description afterwards.
just a tiny thing from me, if like there's no other questions, because it's World Homelessness Day tomorrow. And obviously lots of people who are homeless watch this channel. And just want to say, like, try to not get too annoyed or like whatever with lots of the social media posts you might see. I think it's quite difficult on that day when you're going through homelessness to see lots of organizations either posting about the amazing services that they run or posting about how it's such a huge issue, homelessness, and how dark and depressing it is, and sort of talking about numbers and stats and stuff like that. And I want people watching this to sort of just take it a bit easy on themselves tomorrow potentially, because yeah, I think it's good to raise awareness or what have you, but like it's not always focused on the individuals actually going through the experience. So just to bear that in mind and give people a heads up for tomorrow, I guess.
Yeah, cool. Thanks, Shannon. And then very quickly, there's just a last minute question in there about I think what I was saying earlier about if you complain, there's a chance the council will just be very difficult with you. And I base that on my experience of working in a council. So essentially, when someone was complaining, if the council like begrudgingly followed the law, they would do it in such a way that they can kind of give the most inconvenient possible service. So if someone said, I want it to be on this side of town, they say, oh yeah, well that's not possible. We're going to put it on the other side of town, that kind of thing. So it's just kind of it's very difficult to know how to play that because sometimes you have no idea. But certainly my experience of housing officers behind the scenes is that they don't really kind of play fair. And so even as I say, if you're challenging them and saying they're not following the law, then okay, they'll follow the law, but they'll just kind of do it in such a way that it makes it just very unpleasant sometimes. So I think there's just a risk, impossible to say kind of how each council differs, but it is a phenomenon basically. So that's what I guess I was talking about. But yeah, cool. Thanks guys. We'll be back on next week, hopefully only once, so we don't lose the regulars.
We're back on Tuesday as well.
Oh yeah. So yeah,
Absolutely different.
Tuesday afternoon, intentional homelessness webinar free. Check out on Eventbrite to book on. I've just extended the number of places, so I think it might fill up again, but we'll see what happens. But yeah,